Well, good afternoon, everyone. Thank you for tuning in. It's another Liberty Group webinar event on this Tuesday afternoon. So glad you could join us. I have Gary Lieberman with us, who's one of our attorneys that works with us. And good to see you, Gary.
Hi, Dave. How you doing today?
I'm doing great. Thanks.
Good.
Well, I know this is a really popular subject, and we're really excited to talk to you about it. Before we get started, just want to give you some updates on who we are and what we do. If this is the first time you're tuning in, you can see at our company we're a little different than most in that we do three things we think fairly well under one roof. We do legal work, and we mainly focus on estate planning, elder law, long-term care issues, probate. We did recently add a corporate attorney, so we've been doing some mergers and acquisitions. So if you're selling a business or you're looking to create some sort of a buyout agreement, et cetera, we do have a corporate attorney now on with us. We also do tax preparation. So we have a CPA and an enrolled agent that work with us currently. We are expanding that practice. So look for more of that sort of information and webinars around that tax subject. And then also, a big part of our business is financial services. We do stocks, bonds, mutual funds, ETFs, long-term care insurance, life insurance. So, quite a bit in that area as well. And we do it under one roof, and that's what we're proud about because it's a lot of fun to see the kind of results we can achieve for clients, very much like we're going to talk about today. If you enjoy this, I certainly encourage you to listen to my radio show once a week. Gary and I were on quite a bit talking about this subject on the radio. A lot of you asked questions about it. That's why we're doing the webinar tonight. So thank you for asking us to do this. It's because of you we're doing it tonight. Our radio show is on KMBR in the Bay Area. I know there's some people watching this right now from Southern California, but we are up on the Bay Area on AM 680. And FM 104.5, the old KFOG station, which I miss, by the way. I love KFOG. Anyway, so the show is live on Saturdays at 8 a.m. And we talk about protecting your assets. That's what our brand is all about. And that's me. I'm the Sandman. For those of you who don't know, my clients call me that because I help them sleep well at night. They don't worry about this stuff. So that's the Sandman. If you missed the show, you're not up at 8 o'clock in the morning or you're doing something or whatever, we have podcasts. So what we do every single week, right after the show is over, Kevin Renfer is nice enough. He basically runs my show. Kevin makes a podcast and then he uploads it. And there's a couple ways that you can listen to that. One way is if you have Alexa, you can just say, hey, Alexa, enable protect your assets. And then you can say, hey, play the latest podcast. Or if you have Google, I have Google right behind me, so I'm not going to say this, but you can read right there what you're supposed to say. And then it will connect. And by the way, for all of you listening right now, I have a special message for all of you on there today. So if you would go ahead after this is over and go ahead and connect virtually and talk to Alexa or to Google, you'll see I have a special message for you. So go ahead and check that out. That's where we post our podcasts. And if you listen to Spotify or Apple Music, we have it there as well. So check that out because it's a great way to get information that's current and up to date. All right, well, let's get started. So, Proposition 19, Gary, what is this thing? Tell us a little bit about it.
Well, it was passed by the voters in November, and basically what we're concerned with, our portion of Prop 19. Became effective on February 16th of this year, and it was tacked on to the children inheriting parents' property and the property tax increase. That component of it was actually tacked on to the bill, and most people thought they were voting for wildfire relief and that sort of thing.
Yeah, I remember getting the ballot and reading it, and I never saw this. I didn't know about it until you told me. So
no, it's like a page and a half at the end of the bill. But in any event, it passed by about 51% of the voters. And essentially, before Prop 19, we had Prop 58, which allowed your parents to transfer real property, virtually unlimited amount of property and any type of property, basically, to their children on their death. And there would be no increase in the property tax. Well, Prop 19 did away with that. And effective February 16th, that is no longer the case. Parents can transfer only their principal residence to their child or children, who have to live in the house, by the way. And it's limited to $1 million plus the assessed value. Any other property, whether it be income property, duplexes, commercial property, land, vacation home, whatever, when the parents die, to pass that property to the children, the property is going to be reassessed. Property tax is going to go up and reassessed based upon current market value. So we have many clients, as you know, that are paying property tax based upon 1975, 1980 values under Prop 13, and now under Prop 19, when they die, the property tax is going to go up probably 6, 7, 8, in some cases sometimes tenfold. So wow. The question is, how are the children going to be able to afford this massive, dramatic increase in property tax? Yeah. And of course, we're going to talk about it in a few minutes, but we have a way to circumvent that problem.
Okay, and as we list here, for those who are over 55 and older, I guess we're called seniors now. I guess there's an ability to transfer your tax basis. Is that right? And how does that work?
Well, up to 3 times. It used to be that you could do that once, and the county in which you're buying your new home would have to allow that. But now, basically, under Prop 19, you can sell your house, and it's basically designed for those people that lost their homes in the wildfires. And when they bought a new home, of course, the property tax would be based upon the purchase price. Now they can transfer their property tax base on the house that burned down or the house they're selling to the new house, and they can do that up to 3 times.
Now, on for like a fire victim, basically, I've seen the form and it talks about what you sell it for. So essentially, I guess that helps those people who aren't able to get a lot of money for that property they're probably selling to move.
Right? Exactly.
For those who are getting a lot of money, maybe, I've got a lot of clients around the Bay Area who paid $300,000 for a home, and now it's worth like $3.5 million, and they want to sell it. And they're thinking maybe downsizing or something, or moving to another area. Does something like that help them?
Well, they'd be able to transfer their tax base. So to that extent, yes, it would. But then you've got the tail end of Prop 19 that they need to be concerned with, and passing the property to their children when they pass away. That's the main concern. Okay.
All right. Well, good. Let's. So here's what I'm going to do, folks. I'm going to go ahead and I'm going to open up the chat. And so you'll see here on the right, you can actually start typing comments or sending questions. I want to do that because as we get into the meat of this, you may have some questions, and that way we can go back and answer them. And then if you just want to listen at the end of this presentation, we will have a question and answer session as well. And then we'll also be making a special offer because you tuned in today to get some free information about your situation, but you'll have to take advantage of that offer. That'll come at the very end. Okay, so that's just a little bit about it. I hope to have everybody out of here, no later than probably 30 minutes from now, 35 minutes, just depends on the questions you ask. We're happy to help you. So let's get started. Let's get moving on here. So I find that most of these questions are great. And let me just jump into a lot of these questions because they're pretty good. So let's see here. Robert, so my property tax will be the same dollar amount if we buy a new house in California. I don't think I understand your question, Robert. Maybe you could re-ask that. Janet asked, can this be repealed or a new round which can reverse this? Yes, Janet, that's possible. Raul, about 15 years ago, we created a trust for our assets. Will that have an effect once we pass? It will, but the problem is, let me get here to the estate planning in the wake of Prop 19. This is the big issue, and this is what we're trying to deal with and talk about today. The real issue here is your current trust does not protect you from this new Prop 19. What it does is it avoids probate. So when you die, if your real estate is in the name of your trust that you did 15 years ago, Raul, what'll end up happening is your trustee, who could be your child, your trustee will be able to administer the estate and keep your house out of probate. But what'll happen is the county will reassess your property at the date of your death. And if the date of your death, say the property is worth $2 million and you pay $300,000 for it, what's going to end up happening is your tax rate on your property will step up to that current fair market value, and your kids will have to pay tax based at that new rate if they want to keep the property. So in that instance, if the property tax is say 1.25%, you could go from paying say $5,000 a year in taxes up to maybe $25,000 a year of taxes forever with a Prop 13 cap, but still it's going to step up every year at 2%. So that's the big issue we're talking about, even if you have a revocable trust right now. So your revocable trusts right now don't protect you from what we're talking about when it comes to this Prop 19. What if I think we read that one already. Carol, is there a retroactive period to the 55 and over tax-based transfer? Carol, I'm not sure I understand your question. This law went effective February 16th of this year. And so the way if you want to go look at some things, I would encourage you to go to the State Board of Equalization, BOE, California Board of Equalization. I think it's boe.ca. If you want to write this down, boa.ca.gov/Prop 19. And it talks about the dates and the retroactivity. From my understanding, and maybe Gary will pop back on here, but from my understanding of this, April 14th, I believe, is the date this year where going forward, anything that happens after that date, this is the new rule. Okay, Carol. So I'm not sure if that answered your question, but that's how that works. Okay, I'm going to glide back up to the top and see if there's some more questions. There are. They keep coming in. Good. Okay.
Wheels returning.
Yeah, good. Hey, Gary.
Right, there's Dave now.
Okay, we can hear you. I can hear you, Gary. Can you hear me?
Hear me? Okay, let me turn Dave up, though.
Great. Can you hear me testing?
Well, I can barely hear Dave, though.
Can you hear me now?
Okay, now, yeah, I can hear you, Dave. Okay,
great. Okay, we're back. I got you. They can hear you. So I think we're all good to go. So let's just jump back into it. What I've been doing so far, Gary, is I've been answering some questions. There you are.
Good. All right, let me hang up the phone. Thank you, Kevin.
Thank you, Kevin.
Okay, Dave.
Kevin's my rock star, guys. I mean, Kevin,
no kidding. I'm sorry. I don't know what happened, but in any event, I'm back.
Perfect. Okay, great. So, Gary, let's talk about, I know that you have some background behind our special Prop 19 trust. Let's talk about that and then we'll jump back into questions again. Go ahead.
As far as how I became involved in
how this all came about, and you called me and told me about it, and then we did a radio show, so let everybody know like how this came around.
Right. Okay. Well, basically,
you and I have been working together for like 25 years or so.
Over 30 years. Yeah, over 30 years. We go back a long way. Long way. So yeah, I was talking with one of our colleagues who you know well down in Southern California. He's the past president of the National Academy of Elder Law Attorneys down there, and he does a lot of veterans benefits, and he does Medi-Cal planning and general estate planning. And we were talking about, he said, people's circumstances change so often. Like, for example, their finances change, their health changes, their family structure changes. There's so many changes. He said, and everybody has a trust, or most people have a trust. He said, wouldn't it be nice if we could flip a switch and make our trust accommodate or go along with the change in circumstances that our clients may incur? And a little light went on in the back of my head. I said, well, why couldn't we do that? So I created, it's proprietary to me. In fact, I'm getting it copyrighted. I created a trust, which I call Life and Legacy Trust, which basically is 4 or 5 trusts all combined in one. But the main purpose of it is, I'll explain how it works in just a second. The main purpose of it is Prop 19 avoidance. And I can explain how that works in just a moment. But basically, we set up just a basic revocable living trust, just like a normal standard garden variety revocable living trust with our clients as the trustees. The first people that set up the trust and the trustees, they're in complete control, just like they are on a regular trust. They can do whatever they want with the trust property. They get all the income. They can revoke it, modify it, amend it. But what it has in the trust, built into the trust, is what I call triggering events. And I have over 30 of them. And what happens is the trust says when one or more of these triggering events occur, and one, of course, is death of the parents. Another is incapacity. Another is incompetency. Another is being threatened with a lawsuit. Another is a change in family structure, financial changes, any number of things. There's 30 different triggering events. If any one of those events occur, we can flip the switch and turn our standard revocable living trust into a different type of trust, whether it be irrevocable trust, special needs trust, life insurance trust, two other types of trust that are a little more complicated. We can flip the switch and convert our existing regular revocable living trust into one or more of these other types of trusts. Let's talk about how that works for Prop 19 avoidance. Essentially, what happens is it says when the parents die, the property would go to the children. Okay, and that could be any property, be income property, vacation home, commercial property, undeveloped land, residential, it can be whatever we're talking about. The property would go to the children, but under Prop 19, it's going to be reassessed. What we have built into our trust is it says the property is going to stay in the trust. Although the children can do anything they want with the trust property. They can sell it. They can take it out and sell it. They can get all the income. They can refinance it if need be. They can split it up between, one or more of their siblings. They can do whatever they want with the property that they could as an owner, but it never comes out of the trust. They don't get a deed. The analogy I always give when I'm explaining this to people is this is the trust like the Kennedys have, like the Rockefellers have, like the Bezos have, okay? If you check to see when they die, their kids aren't going to own any property. Everything is going to be in a legacy trust, which is going to pass down from generation to generation. Well, that's the same concept of my life and legacy trust, okay? We've been doing this for years. We call it a dynasty trust is what we call it. However, and that's for the very wealthy, and it's to avoid federal estate tax, and it's for asset protection, that sort of thing. But the downside to a dynasty trust is where the property remains in trust for generation to generation to generation is, number one, it's irrevocable, which means that once it's done, you can't undo it. Kids can't take the property out and sell it or do whatever they want with it. Number one. Number two, there are many, many, many restrictions. My life and legacy trust has no restrictions, none whatsoever. And although it can be irrevocable, it does not have to be irrevocable. So the kids they get the full use of it, the full benefit of the property. They just don't get a deed. Because they never get a deed, there's never a transfer, which means the property tax never goes up. There's no federal estate tax. There's no change whatsoever in the property tax structure. Now, if they want to take it out and sell it, they can do that. Okay. If they do that, obviously the property tax is going to be reassessed. But if they're selling it, it doesn't make any difference.
Gary, how about this one?
Ongoing tax liability.
Gary, let me ask an obvious question. Can you hear me?
Sure.
What about a refinance?
They can take the property out just like they can under a normal revocable living trust and refinance it, and then put it right back into the legacy trust. There's no restriction on that whatsoever.
Good.
So that's how the Prop 19 avoidance works. The other types of trusts, again, depending upon a change in finances, a change in family structure, like, for example, one of the children has some special needs, we can flip the switch and create a special needs trust. If we need it for asset protection, we can flip the switch and turn it into an irrevocable trust. We can form an LLC with the trust assets. We can do a life insurance trust, which is as you know, is a good tax planning device. So it's very flexible, very versatile, and basically the bottom line is it's like 5 trusts in one. And there's no reason to think that it won't work because, as I say, the underlying concept, we've been doing ever since the day one. Now, I've been at this for 45 years, and I've done legacy dynasty type trusts ever since the day I started practice. So that's how it works. Basically, it's a quick overview, but that's the concept.
That's really helpful. That's really helpful. All right, why don't I do this? I'm gonna get into some questions here, Gary. You and I can QA, and then at the end here we'll take some more. So Mike has a question, which I think is pretty good. It says he was a 50% owner in his son's home. And then he wanted to know, will his son's property tax go up on the half he's on title for if he dies?
Yes.
Okay.
Absolutely. Yeah.
Okay. Robert, will I pay what I pay now? What exactly transfers? So Robert, I think we answered your question. You're going to keep paying your taxes just like they are. There's no change to that. And if you do this type of trust, your kids will get the benefit of what you're doing and won't get a giant step up and have to pay that huge new assessed value.
Right.
Cindy, if the parent passes on their primary residence to their child, do Prop 19 reassessments still apply? Gary, let's ask that a little differently, because I know Marilyn's tuning in right now, and Marilyn asked me a question offline, which is a similar question to Cindy's, which is this. Let's assume that Marilyn bought her property 25 years ago. She paid $300,000 for it. Today it's worth about $3 million. She dies in, say, 20 years. Cindy, maybe your parents die in 20 years. I'm just saying, I don't know anything. The question is, at that time, what will the tax be if you keep the property on the primary residence?
If it's the primary residence, it has to be your primary residence passing to your child or children as their primary residence. Now, the law is unclear. It says child. So what happens if you have 3 children? We asked that question of many assessors' office and never got the answer. But we believe that if one of the children resides there as their principal residence, it's going to be exempt from reassessment up to $1 million plus the assessed value. So if we're talking about a property that has such a low tax basis, then when Marilyn passes away to get this property to her child or children, okay, it's going to be limited to, and it has to be their principal residence. They have to reside there within 1 year of her death. And by the way, nobody's going to check on that, but still, nonetheless, that's the law. But it's limited to $1 million. So you would add $1 million to whatever her assessed value is at the time of her death. And the difference to current market value is going to be taxed. So in her situation, probably there's going to be a proportional increase in the property tax.
Yeah. So Cindy, again, if you go read this Board of Equalization website I gave you guys earlier, this is a big question. This is a really big fundamental problem that not only you asked, but Marilyn's asking us, which is, is this kind of unlimited if it's a primary residence? The answer emphatically is no.
No.
You basically get the $1 million plus the assessed value, your parents' assessed value. That's it. Anything that the property is currently worth today, you're going to have to pay taxes on the difference. And that could be a really big number. So the reason that we're recommending this special Prop 19 trust that we call it is because you can avoid all of that. Period.
Right.
Okay, good. All right. So just make sure everybody's clear about that. It's a really important point. Peter asked a question. The house we are inheriting is 1/6 my grandparents who left it to my mom. When we sell it, is the Prop 19 still an issue in Massachusetts? Yeah, it doesn't matter because this is only California we're talking about. The property that resides in California is subject to Prop 19.
Right. One point, Dave, by the way, when we talk about the property is going to be reassessed, it's going to be reassessed at current market value. Guess who determines the current market value? The assessor's office. Okay. Yeah. That's who determines what it's worth on date of death. So the mechanism to challenge that is not yet in place. But the bottom line is we really have no say-so in it. The assessor is going to tell us what the current market value is.
So for everybody asking the question, yes, this will be recorded. It will be edited, so it takes out that whole reverb stuff. But you can watch this at a later time. Just check in again with us to find out more about that. I'll give you the ability to do that here in a minute. Let's get into some more questions. Okay, Robert, my property tax will be the same dollar amount if we buy a new house in California. Not necessarily. I believe what we said earlier is if you're over 55 and you buy a property of, say, greater value, what you're going to get to transfer would be your previous assessed value.
That's right.
Plus what? Is there anything on top of that in relation to your new home? So again, I guess we use the example where let's say they sold their house for $3 million. Their basis was, or their assessed value was $350,000. They buy a new property, say that's $2 million. what will the new property tax be based on if it's all in California?
Yeah, there's no limit. It's going to be based on what their original property tax basis.
Okay. Plus, if they do, my understanding is if they do improvements on the new property, they can pay tax on that.
It can be reassessed. Yeah. Absolutely.
So
and,
Robert,
it could go up 2% a year also under the current tax law. Right.
Prop 13. Yeah, Robert. So Robert, I think I answered your question, or we answered your question. If you have more, go ahead and type below, but I think we got you. Janet, can this be repealed or a new round, which can reverse it? Sure. I mean, look, the legislators can do anything they want. If we vote on it, obviously, this passed by 51%. It was obviously very controversial, but everybody's got to get out and vote, right? And they got to vote and make the law change. So right now, this is the law. This is what we're dealing with. And if you're trying to protect your family, you got to take care of this. You can't let it just sit there because it's a problem.
Right.
The slides, they're not much better than right here. So if you want to look at this and look at it, fine. What Gary basically said, that the upshot of this whole thing is, Prop 19 is there. If you want to review what the government says, go to their website, boe.ca.gov/prop19. Read it. Understand that you need to talk to an attorney because we're the ones who know how to interpret the law. We have a proprietary Prop 19 trust, as Gary explained, that rolls up all these different types of trusts into one new trust that you can flip switches on and off depending on what happens in your life. So it's extremely flexible. That can take care of this issue. So it's really that simple. We're happy to talk to you more about your specific facts, and I'm going to put that up here in a few minutes to let you do that confidentially and at no charge, but just bear with me here. Okay, Janet, what if my parent passes and her trust wants to pass property to us kids? Janet, that's where the problem arises. So I would bet 99% that you don't have this type of trust. Your parents don't have this type of trust because it didn't exist back then. It's new. And you're looking at a problem. So, you kids out there who have parents' properties you're expecting to inherit, this might be the opportunity for you to pay for this. You hire us, we talk to your parents, you pay for it, and then you get the house or rental properties, and you get a lot of flexibility if you're indeed the beneficiaries of that. Not a bad idea.
That's a good point, Dave, that you just raised. It not only applies to principal residence, it applies to your parents' vacation home, commercial property, duplexes, triplexes, apartment. We have we're putting a 19-unit apartment house into the Life and Legacy Trust. So it's all forms of real property is what this applies to.
Absolutely. Okay, here we go. So let's see. I have 2 rental properties and 1 personal home in California. Can they sell within 1031 guidelines the 2 rentals? Yeah, you should be able to 1031 exchange that. I mean, we can get into more details about that. But for now, my understanding is they're not changing the 1031 federal law. So you should be able to do that. The issue will be on your primary residence, and any rental properties that you 1031 into, you're going to be moving that basis into that new property. And if you, as Gary just said, if you want to protect and preserve that for your kids who would inherit that property and receive income off of that in the future, you got to look at this Prop 19 trust. Otherwise, they're going to have another cost that'll deduct from their cash flow every year, and that's just going to hit the pocketbook. Period. End of story. So,
right.
Todd, is there any lawsuit being brought to revoke Prop 19? Gary, do you know about that? Anything?
Not that I'm aware of. We work very closely with a lobbyist in Sacramento, and he's telling us they've heard nothing. There's nothing of any challenge. There's no lawsuits, nothing that anybody knows about to challenge it. So it looks like it's here to stay. Okay.
Roger asked a great question, which I think is perfect for our transition here in a couple of minutes. Because again, I promised I'd try and get you guys out of here around 45 minutes after the hour. I'll give maybe a minute or so more. Which is this: what's involved in changing? So let's say someone's got a house, rental properties, in a revocable living trust right now, Gary, and they want to take advantage of our Prop 19 trust. First and foremost, I'm going to put up an offer here in a minute, which is going to give you the opportunity when I turn this off. Okay, it'll be up here for 15 minutes, so don't feel like you got to jump and click it. But you have plenty of time where you can click it, and then you can set a time that's convenient for you to talk to us, and then we'll walk you through what's involved in doing this. But Gary, I mean, this is it takes us time to do the work, but it's pretty easy, isn't it? Particularly if you have a revocable living trust already.
Well, yeah, the way we'll do that is we will what we call amend and restate the existing trust, because we don't want to put cash, assets, stocks and bonds and that sort of thing into the life and legacy trust. There's no, I mean, we can, but it's basically for real property. But let's just say we want to put everything into one trust. We can take the existing trust and amend it and restate it and create a life and legacy trust within that trust. So we don't have to start from scratch. Good question.
Great. And this next question is really good. So Roger, I hope that helps. Patrick asks, I'm single with no children. Does this apply to my beneficiaries if they receive the property? And, you know, obviously he's saying because they want to hang on to it. Does that apply?
Yeah.
Does it work?
Yeah, absolutely. Absolutely.
Good. Nellie, how does the life and legacy trust work with the IDIT that we completed before effective date of Prop 19? I guess they're already good to go, right?
Yeah, good question. We were doing the irrevocable trusts before Prop 19 went into effect, before February 16th. That was an estate planning tool that we used. We can no longer use that tool, but nonetheless, there are good reasons to keep the irrevocable trust. But again, we can still do the life and legacy trust within the IDIT, the irrevocable trust that we did.
Good. Scott, my 98-year-old mom owns a personal residence and 2 rental properties. I have 2 siblings. If we use this Prop 19 trust, I guess, will it work or something like that? I think that's what Scott's asking.
Well, yes, if it's in the trust, absolutely.
I bet you a 98-year-old person has a very low cost basis. I mean, I would be willing to bet on that.
Yeah. I would think you're looking at the property taxes going up 6-7 times at least.
Oh my gosh. Yeah, Scott. So if any of you or your brothers or sisters, if any of you are thinking of hanging on to any of these properties, this is cheap insurance.
Absolutely.
Janet, what's an IDIT? It's an intentionally defective irrevocable trust. We use them for creditors and other situations. That's not what we're talking about right now because the law has changed. And so we're talking about a Prop 19 legacy trust, which works for rental properties, personal residence, any sort of real estate that you might have that you're planning on leaving to family.
Yeah, it's important to note that we were doing the irrevocable trusts in order to beat that February 16th deadline.
Yeah, and it worked.
It worked. But if we didn't do it before February 16th, then we'd be in deep trouble. So that's why we were doing the irrevocable trust at that time.
Yeah, and that was mainly on residents as well. We didn't have flexibility, which I know a lot of our listeners right now have rental properties. And I got to tell you guys, if you have rental properties, like I do, it's a good source of income. You could put a property manager in there, still have positive cash flow, still keep that property low cost tax basis, pass it on to your kids, multiple generations we're talking about. I mean, as Gary made a point, the Bezoses, the Rockefellers, this is what they do. I mean, come on, this is what they do. So it's time for you now to take advantage of what they know. Do this for yourself. Again, this is not terribly expensive. It pays for itself in a matter of time. And it's something that is really easy to do. So here's what I'm going to do. I'm going to go ahead and put up an offer right now. I'm going to go ahead and start that currently. It's going to sit there. We'll take maybe 1 or 2 more questions. And then I want to honor Gary's time here. I really appreciate him getting on with me today. Thank you, Gary.
Thank you.
He's got a super busy practice, and I really appreciate him jumping on with us today. All right, question from Martin. How will this affect a GST, Gary, otherwise known as a generation skipping trust?
Well, it qualifies. I mean, if parents decide they want to leave property to their children, or let's just say they say, no, I want it to go to my grandchildren, it still has the same effect. We still use the Prop 19 avoidance trust, and it has the same effect. Doesn't matter if it's children or grandchildren. Excellent.
Good. Scott asked a question so back to Scott's question, which was 90-year-old mom has a personal residence, presumably with a very low basis, 2 rental properties. If his brother and sister want to sell those properties when mom dies, can they force Scott to do that? What sort of options would Scott have?
Well, the answer to that question is yes. The siblings can force a sale. It's called a partition action. They're not going to be forced to be partners with one another if they don't want to be. The good thing about the life and legacy trust is we can, let's just say there are 3 properties in it. We can carve out 2 of them and have a inter sibling sale, or we can trade off properties. We can trade off equities. We can certainly do that. But the answer to the question is yes. One or more of the siblings can force the others to sell or sell out, as the case may be.
Great. Okay. Gary's been doing this for over 40 years. He's a real estate expert. He knows real estate. So we're really lucky to have him on today. Really thank you for doing this, Gary.
Thank you for having me.
I know our watchers and listeners indeed appreciate it as well. If anybody has any more questions, I'll give you about 30 more seconds. Happy to take them. And then what I'll do is, as you can see, I've published the get together with us. It's a free now. There's no charge for this. Free 15-minute consultation with us, and we're more than happy to walk through your situation, let you know what you're looking at, what it would cost. And it's totally up to you to decide if you want to do it or not. I would recommend that if you have parents, have them watch the replay of this when we do it again. Certainly go back and listen to the podcast. Gary and I did a radio show where I talked about the subject with him on the show. You can find that at KNBR's website. You can find that at our website or anywhere you get a podcast. Just ask for Prop 19 at the Protect Your Assets podcast. You can find that on either Google, Alexa, or on Spotify. Again, Protect Your Assets is the name of the podcast. Protect Your Assets, and you can type in Prop 19. Okay, Gary, I guess that does it. No more questions.
Well, I have a question.
Go.
Excuse, you know how technologically challenged I am. As I'm looking at the screen, what does someone do? Just click on the green phone and that connects to your office to make an appointment?
So you and I are privileged because we're presenters. Everybody who's watching us right now on their screen has a offer that says click here, and then they'll get a link immediately to get an appointment. And then all my team, I got to thank my team. I've got a lot of people at the office right now looking at your questions, taking down information. If you want to schedule that meeting, we'll definitely get that all coordinated and scheduled. Okay. Gary and I don't do that. Our staff does, and we're really lucky to have them. We're very appreciative of what they do.
They're very, very good, very efficient, very, very good.
So we thank them very much.
Yeah, for sure.
All right. Excellent. All right, guys. Hey, Gary, thanks so much. And to all of our watchers, stay tuned, and we'll be doing more of this. I'm going to go ahead and leave this up, Gary. You just have to click the screen at the camera at the top and the mic. You and I will shut off, and we'll just leave it here for everybody else. Goodbye, everybody. Thanks again.
Dave. Good to see you. Take care, Dave. Thanks. Bye-bye.